An attorney's job is to advance the client's cause. But what if the client thinks the only way to win is to lie in court? In Nix v. Whiteside, the United States Supreme Court pondered the constitutional implications of a lawyer's refusal to let a client commit perjury. Late one night, Emmanuel Whiteside and two other men went to Calvin Love's apartment looking for marijuana. Love was asleep in bed with his girlfriend. Whiteside and Love got into an argument. According to Whiteside, Love reached under his pillow and started to move toward Whiteside. Whiteside stabbed Love in the chest. Whiteside was charged with murder. Attorney Gary Robinson was appointed as his defense counsel. Whiteside initially admitted he hadn't actually seen Love pull a gun from under his pillow, but said he was convinced that Love had a gun in his hand. Robinson assured Whiteside that to establish a claim of self-defense, he needed only a reasonable belief that a gun was present. Later, while preparing for direct examination, Whiteside changed his story, claiming he'd seen something metallic in Love's hand. He said, quote, "If I don't say I saw a gun, I'm dead," unquote. Robinson informed Whiteside that saying this in court would be perjury and that Robinson would have to tell the court. Whiteside testified at trial that he'd believed Love was reaching for a gun but hadn't actually seen a gun. The jury found Whiteside guilty of second-degree murder. Whiteside moved for a new trial, claiming he'd been deprived of a fair trial by Robinson's admonitions not to say he'd seen a gun. The trial court denied the motion. The Supreme Court of Iowa affirmed Whiteside's conviction. Whiteside petitioned for a writ of habeas corpus, which the federal district court denied. The United States Court of Appeals for the Eighth Circuit reversed, finding that Robinson's statement that he'd tell the trial court if Whiteside committed perjury was a threat to violate the attorney's duty to preserve client confidences. The United States Supreme Court granted cert.